Hello everyone. Good evening. Good evening, everyone. Can we hear me? Good evening. Sorry for the little delay. Good evening. Can we all hear me?
Yes, sir.
All right.
Good
Good
evening, we
evening.
can hear you.
Thank you all for joining. Welcome to class. All right. We'll be starting right about now. Sorry about the little 1 minute delay. All right. Welcome to week 3 of the Jiipcc Mentorship and Internship program. We have, well, I would say technically we are at the middle of the program technically, right? And I want to hope that, so far so good in the program. We have been learning quite a lot, and we have been enjoying the process so far. So not to waste our time today, in today's class, we'll be discussing IP infringements, IP registration, infringements, and enforcements. Right, and we are expecting 3 mentors in today's class to help us do due justice to today's subject matter. Right, and I will just be kindly starting off by introducing them. Right, one of the mentors that we are expecting in today's class is Mr. Polarin Aluko. Mr. Polarin Aluko, I think we have read his profile in week 1, and we will not be doing that again today. But this is just us saying a big welcome and thank you to Mr. Polarin for opting to being a mentor for today's session. And we look forward to having you in today's class, helping us to discuss the intricacy of IP registration. Secondly, we are having in class for today's session, we'll be having Mr. Max Ikombe. Mr. Max Ikombe, I don't think he needs any further introduction. We had him in week 1, right? And also I'm not sure if he was around for week 1, week 2, but I'm sure he was around for week 1. Thank you so much, sir, for coming on board. We have learned quite a lot from you over the course of the sessions you have shared with us, and we are happy to have you again in class. And last but not least, in today's class, we'll be having Mr. Sand Mbakalu. Mr. Sand was with us last week while we discussed IP for creatives and for inventors, right? And I'm sure he will be here once again to just help drive the dialogue that we'll be having today. So that's for introduction for our introduction today. Sorry, I can't turn on my video. My background is a bit dark. So I will just be speaking of a turned off video, right? So what will be our agenda for today? In today's class, we'll be taking presentations from the mentors that are on board. They'll be giving us an introduction into what they have planned or prepared for us in today's session. And then after that, we'll be taking presentations from the mentees. I am technically sure of one group making presentation, that is group 2, if I'm not mistaken. I'm not sure if group 1 will be able to make presentation, but if they would, we'll really, really appreciate that. And then we'll go back to feedbacks from our mentors, and then we'll take questions and then call it a day. So not to waste any further time, seeing that we have quite a number of people already in session, and one or two of our mentors are already on board. We would like to hand over to Mr. Max Ikombe. I can see you already on the call, sir. You're welcome today. I trust you had a good day, sir. We would just like to hear from you in the next 20 to 30 minutes. Give us your introduction into the topic for today. You're welcome, Mr. Max.
Thank you very much, Dennis. It's as always a privilege to be back on the Jiipcc mentorship program. I thank you, and I thank Sophia as well for your diligence and steadfastness in putting this together. I also thank my fellow mentors and my ogas who are also on this call. I don't know if they have joined yet, but for the mentees, just know that Mr. Folari Aluko, of course, is also my mentor. So you can as well say we have a grand mentor on the call today. Of course, Mr. Sandu Bakalu is another very distinguished person who is doing a lot, particularly in the policy and advocacy space for IP in Nigeria, in Africa as a whole as well. So I just want to also thank the mentees for joining and to let you know that you are quite in a privileged place and position to have access to some of these mentors that Jiipcc has been able to bring on board today. I do not intend to take too much time with my introduction because I'm looking forward to the presentation by the groups and then, of course, the interactions that come after that. So I'll just try to say a few things. I'll start with IP registration. So when we talk about IP registration and why IP registration is important, is that unfortunately a lot of people, particularly startups, and I'm focusing particularly on startups because I expect that for most of you on this mentorship program, your first set of clients and the first set of people you are going to engage with and be able to help will likely be startups. We have a lot of them, particularly in the fintech space, exploding all over the place. But unfortunately, it's something I've seen, I've experienced firsthand within the Nigerian and even the African, particularly the Nigerian space, because I've engaged with startups, fintech tech guys from other countries, and to an extent, in my own humble opinion, I have found out that I seem to see a lot more understanding and appreciation of IP from founders in other places than I see in Nigeria. They may not have all the technical details, but you can see that they have a basic appreciation of what IP means and the importance and the relevance of IP to their business and to their business model. But I don't really know why, with respect to the Nigerian startups, a lot of them have engaged with, and I've also been in the spaces where it's not just engaging one or two of them, but in the conference and the programs put together by startups. I worry a lot that I do not, that their knowledge and their appreciation of IP, seems to be quite low. So I'm just saying that, it really behoves on us IP professionals to really understand this knowledge, take this knowledge out there. Of course, part of what I'm hoping we'll see is that after your time on a Jiipcc mentorship, you become active on social media, trying to bring bite-sized knowledge, bring IP knowledge in very fun, interactive ways that a lot of these startups can really be able to begin to learn and appreciate, what IP means to their respective businesses and their business models. So IP registration is important because, to a large extent, registration is where the whole journey starts. I mean, before registration, of course, there are things that need to be done. So first and foremost, there needs to be sort of like an audit where the organization or the business sits down to take an inventory to assess what are the different IPs that are relevant, or produced in the course of our business. And then it's when that has been done, then the next question now becomes registration of the IP. So one of the important things that we need to notice that each category of IP has a different regime, different considerations around its registration. And this is important to note because if you do not have that at the back of your mind and you get it modeled up, then you might end up losing IP protection. So I'll start with copyright. Copyright, as we know and we understand, arises automatically from when it is created and is, there's a fixation of that work. So fixation simply just means reducing that work into a medium that it can be appreciated by human beings. So if it's a literary work, for instance, a story, a novel, the moment you write it down on paper, that is fixation. If it's a musical work, the moment you write down the notation of the melody, or that serves as fixation. A sound recording, the moment you record it, an artistic work, the moment you create it, if it's a sculpture, the moment you are done, molding it and all of that. But fixation just simply means putting it into a form that can be appreciated by human beings. And why that is important is because we remember that IP is not out to protect bare ideas. It's like in copyright, for instance, it's protecting the expression of those ideas. So if you have not put those ideas into a form, you have not fixed it in a form that can be appreciated, then you do not yet have a copyright work that is worthy of protection. So copyright, automatically the protection arises from when you have produced the work or published the work, or you have fixed the work in a medium. So what that means is that your protection is not dependent on any formal registration, at the IP registry. However, in Nigeria, the Nigerian Copyright Commission has what they call a voluntary deposit scheme, where you can voluntarily do a, in quote, registration of your copyright work. Why that voluntary deposit scheme is important is that you might need it. It serves as a good basis of proof of when you created the work and of your ownership of that work. Because if two people are arguing about who first created the copyright work, the person who is able to produce a certificate of voluntary deposit would likely, would likely be able to carry the day. But now, another important thing we also tell, particularly startups, is that because you need to also understand that the duration of protection for copyright, of course, is dependent on the type of work. So a copyright authored by a human person in Nigeria, the protection lasts for the lifetime of the author and 70 years after the author has passed on. But if the work is produced by a corporation, a company, or a government agency and all, then it lasts only for 50 years from the time of its creation. Of course, certain copyrights already have a blanket 50 years. So broadcast, for instance, has a blanket duration of 50 years. But with respect to fintech or startups, and particularly fintech startups, copyright, for instance, protects their software codes that they use to design their products. So one of the advice we give them is, when you do those products, always ensure that you create the work as an individual author, and then you can transfer or transfer or assign the right to your company. If you do it that way, then you enjoy the duration of the lifetime of the author and the 70 years rather than just 50 years if you had come up with that copyright work as a work that arose from your company. So these are little issues that, are just strategy-wise that helps to give longer length of protection. So we need to have that at the back of our minds, that with copyright, registration is not a requirement to enjoy copyright. Now, when we move over to trademarks, it's slightly different. Now, with trademark, you need to understand that to enjoy the benefits of suing for a trademark infringement under the Trademarks Act, you must have a registered trademark. And what we mean by a registered trademark is that your trademark must have got to the point where you have gotten the certificate of registration. Now, there's a common misconception in Nigeria, and this misconception arose from processing NAFDAC registration of products. Now, by law, before you can register your product in NAFDAC, you have to have reproduced evidence that you are the owner of the trademark or the brand name you are using for those products. But because there was a period where the Nigerian Trademark Registry was having so many challenges, and sometimes it will take 2, 3, 4, even 5 years, and you won't be able to finish processing and getting your trademark registration certificate, particularly because one critical step of the trademark registration process, the publication of the journal, was at that point taking forever because of bureaucracy in the registry. So because of that, a regulatory arrangement was made between NAFDAC and the trademark registry, where NAFDAC would accept the acknowledgement and the acceptance letters of trademark registration as evidence of trademark ownership for the purpose of registering products in NAFDAC. So because of that, the common impression people now had was that the moment I have an acceptance letter from the trademark registry, I already have a registered trademark. Now that's a huge error, because with that, you cannot bring a trademark infringement claim in court. You must get your trademark registration certificate. So, however, if you do not have trademark registration certificate, you can still bring a claim, where somebody infringes on your trademark under the law of passing off. But we know that under the law of passing off, you have to prove the reputation of your goods, the goodwill that you have built over time in those goods, which can be, just added burden of proof. But if you have a trademark registration certificate, you don't have to prove any reputation, you don't have to prove any goodwill built in the product. The moment you have a trademark registration certificate and the person has sold goods or services under a mark that looks similar or confusingly similar to your trademark, automatically you can sue him, for trademark infringement. So that is, that shows us now that with trademarks, unlike copyright, where registration is not a requirement, with trademark, registration is advisable, because without registration, you cannot enjoy the protections provided by the Trademarks Act. So we can see the spectrum from copyright is not a requirement to trademark, it's advisable to get trademark registration. Now, when we move on to patents, this is where it gets interesting, and is one place also where I advise, in advising startups, we have to advise them right. Now, with a patent, the registration of a patent depends on novelty. That means it must be new, never disclosed or used anywhere in the world before you come to register that invention. So it therefore means that even if you yourself put your invention into the market, or you release it, or you publish, or you start selling products that have that invention embedded in it, even you yourself will lose the right to register that patent, because the moment the patent is disclosed to the world, it is no longer novel and can no longer be registered. So that therefore means that, of course, there are tiny exceptions. For instance, if you demonstrated the patent in an industrial fair, then you have a period of 6 months to get it registered. So what that means, therefore, is that in the spectrum from copyright, where we say it's not registration, not a requirement, to trademark, where we say it's advisable, but now to patent, where it is compulsory. Without registration, you lose the right to protect your patent. So again, coming back to startups and fintechs, what we advise them is, if you have patent-worthy product or elements to your product. Of course, we know that with startups and with startups, they are always looking for financing. They're looking for strategic partners. So sometimes the mistake they make is where they go to try to demonstrate, proof of concept of their product or their service, they end up disclosing those patents and the inventions to people. Or sometimes they want to do like a demo product and put it out in the market. By doing that, that's first registering their patent, they would forever lose the right to patent. So what we advise them is, if you must demonstrate your product to third parties, maybe to financiers, then ensure you do it under a non-disclosure agreement. That would ensure that even though you have demonstrated it to them, once you did that under a non-disclosure agreement, then it still protects your right to be able to register the patent. Same thing also, of course, applies to industrial designs. So with this, I hope we can see the spectrum from copyright, where registration is not a requirement, to trademark, where registration is advisable or is necessary if you want the protections of the Trademarks Act, to patent, where registration is mandatory or compulsory, and without registration, you forever lose the right to protect that patent. So like I mentioned, in advising startups and new businesses, these are some of the things we should put at the back of our mind in helping them formulate their IP strategy or their IP management model in their respective companies. So I think at this point, having looked a lot at IP registration, I believe I would like to stop at this point, and of course, let the next mentor also have a go before we listen to the mentees. So thank you, Dennis, and back to you.
All right. Thank you so much, Mr. Max, for your very wonderful introduction. We really, really did enjoy it. In your introduction, you were able to show us the spectrum from which registration is required from registration is required um, both copyrights from copyrights to trademark and then to patents, right? And how it's physically and the exceptions that may occur based off of industry standards. And thank you very much, sir. We really, really did enjoy that. So far, Mr. Max is the only mentor we have on call. We are trying to work on having more of our mentors join in. So for the time being, what we'll be doing is that we'll be taking presentations from the mentees. If after the presentation and we still do not have more mentors join in, we would head back to Mr. Max in his comments. We would also like for him to add more or share more thoughts with us as it regards maybe infringements and then enforcements, right? So that's the trajectory we'll be following this evening. So, all right, I was informed that Group 1 will be able to make their presentation in class today. So please, we would like to hear from the Group 1 presenter based off of the presentation that was made. You can kindly do well to start your presentations, share your slides, and then for next 15 minutes, right, make your presentation in 15 minutes, and then we'll head over to Group 2 for their 15 minutes presentation also. So please, the Group 1 presenter, you can kindly unmute, share your slides, and start your presentation.
Good evening, everyone.
Yes, good evening.
Please, can everyone see my slide?
No, we cannot see you. Are you sure you're sharing?
Yes.
Okay, can you undo it and try again and retry?
Okay. Can everyone see my screen now?
Sorry, sir.
So we still cannot see your screen. Or am I the only one? Please, can someone confirm?
Sorry, sir.
Maybe
No, I also can't see the screen.
all right, so we cannot see your screen. Can you kindly start your presentation? I'll try to see if I can gain access to your work and share from my end. Hello. Presenter, are you with us? Okay. If our presenter is having issues, please can we have Group 2 present and then we'll go back to Group 1 for their presentation. The Group 2 presenter, if you are ready, we'll take your presentation first and then we'll move back to Group 1. Presenter for Group 2.
Okay, good evening, everyone.
Yes, good evening. We can hear you.
Okay. 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 Can you see my slides?
Yes, we can.
All right. So my name is Ewo Mazino Iwo, and I am the presenter for Group 2, and our topic is on IP enforcement and arbitration of IP disputes. So what is IP? Can I continue something?
Can I continue? You can. Yes,
Okay.
you can. Your voice is very good, but you can.
Yes, I'm having a little network issue. Sorry. Okay, so what is IP enforcement? IP enforcement is basically how you protect your rights and stop infringement. And there are two types of IP enforcement, which is the physical and the online IP enforcement. And we'll first talk about physical enforcement. And physical enforcement, as the name suggests, are physical, that is online, real world actions taken in order to stop infringement. And there are some enforcement mechanisms that you can do in order to stop infringement, which include court-ordered inspection and seizure. So, for example, when you file a lawsuit in court to stop an infringement, the court can issue measures like injunction or damages to enforce IP protection. And then we also have administrative and custom enforcement. This is when government agencies or customs, they raid markets or shops to seize fake goods, or they prevent the goods from entering the market in the first place. And examples of these agencies are like NAFDAC or the Nigerian Copyright Commission. And then we will now look at online enforcement. So online enforcement is the opposite, which are actions taken on the internet to enforce, to stop infringement from happening online, basically. And the mechanisms to be able to enforce online enforcement include social media enforcement by using social media apps like YouTube, Instagram, and the likes. They all have systems in place in order to stop infringement. For example, YouTube, they have this copyright system where they issue you 3 copyright strikes. Like by the 3rd strike, they will take down your channel. So this is a very effective way to enforce IP. And then secondly, customs and border monitoring. So by using online systems to spot and block counterfeit imports. So for example, now some companies, they basically go online to monitor the internet for fake or copied content and take them down. And then we also have judicial authorities. These are practical examples of how courts enforce IP protection in practice. Beacham Group Limited and Ors versus SD Food Products Limited. So in this case, the court affirmed the physical seizure and injunction against infringing products, and there are further examples. So moving on, we're going to talk about the challenges to enforce these IP rights. So first of all, diverse IP laws. So for example, now a lot of countries, they have several laws in which they use to protect their IP. So for example, what is protected in Nigeria may not be protected in a country like the United States or China. And then we have cross-border complexities. So issues like, okay, which court has more authority, which laws applies, all these things, they pose significant challenges to enforce IP. And then we also have limited legal remedies. So some countries may only grant injunction, but not damages. And some countries might not even give any punishment to the infringers, so basically leaving them scot-free. So all these things pose challenges. We also have slow judicial processes. As we all know, the judicial system takes years, sometimes it may take years before they can even get a judgment. And by that time, the parties might have moved on so many things would have happened by that time, and it kind of defeats the purpose of carrying it to court in the first place. And then we have anonymity of infringers, which makes it difficult to trace the real culprit. So a lot of all these infringers, particularly on the internet, they usually make their identity hidden. So you do not even know who they are. So it becomes very difficult to actually trace the real culprit. And then we also have high cost to enforce IP protection. It's very expensive because most of the time you have to hire lawyers, investigators, you pay expensive court fees in order to try to protect your intellectual property, and it is quite expensive for the everyday businessman individuals on the streets. And we also have operational and logistical challenges like sophisticated counterfeiters. So a lot of all these counterfeiters, they are becoming more sophisticated. That is becoming a little bit more difficult to distinguish between fake products and real products in the market, because they are finding ways to make their product as identical to the original as possible. Then we also have resources constraints for enforcement agencies. So enforcement agencies like, let's say, NAFDAC and the likes, they have constraints like maybe low manpower, not enough funding and the likes, which makes it very hard for them to basically do their job and enforce this IP protection. And then also inadequate technology infrastructure. Countries in Nigeria now, our technology have not really met up with the current technology of the world today. So it's making it a little bit inadequate, so posing a major challenge. And then underdeveloped awareness. A lot of people do not even know that they need to protect their IP rights in the first place. So economic and sociopolitical challenges, high cost of enforcement, which I've talked about earlier, corruption, socio-economic factors, political interference. So let's go to arbitrability of IP disputes. So what is arbitration? Arbitration is where both parties agree to submit their dispute to an arbitrator instead of going to court. So the key word here is that the parties have to agree to submit their dispute to an arbitrator to resolve their disputes. If not, the arbitration will not even be binding in the first place. And arbitrability is whether the dispute can be resolved by arbitration. So now there are instances where arbitration can be used to resolve IP disputes, which are first, inclusion of an arbitration clause in a contract. So when an arbitration clause is included in a contract, then that dispute can be resolved in arbitration by arbitration process. And in IP sense, contracts like licensing, franchising, merchandising, yes, if there's a clause, an arbitration clause in the contract, then if a dispute arises, it can be resolved by arbitration. And then we also have domain name disputes. So when a domain name dispute arises, like for example, let's say www.coca-cola.com and the other domain name is www.cocomelon.com. Maybe they might be having some issues. They can go to arbitration, which WIPO is World Health Organization, and we also have Uniform Domain Name Dispute Resolution Policy. So these are arbitration in place. These organizations have arbitration in place for this kind of issues to be resolved. And then we also have through specialized forums, the World Intellectual Property Organization Arbitration and Mediation Center provides a place where arbitration issues can be resolved. Okay, so and another major note, arbitration does not cover criminal matters. So laws guiding IP arbitration in Nigeria include Arbitration and Mediation Act 2023, the Constitution, the 1999 Constitution as amended, Trademark Act 1965, Federal High Court Act, Copyright Act 2022, international treaties like TRIPS Agreement, WIPO Convention, and the likes. Okay, so benefits of IP arbitration, confidentiality, expertise, neutrality, party anonymity, finality, like essentially all these benefits of arbitration is it's faster, way more faster than court processes. There is confidentiality. The parties to that arbitration, they keep it is a tight-knit something that is between themselves. It's not like open, like for example in the court setting, it's public record. So a lot of people can have access to the dispute that happened between them. But for arbitration, is more close-knit and more internalized. And neutrality, it's just essentially more faster and efficient process. And then we have limitation of IP arbitration. Okay, so there is this constitutional ambiguity. So except criminal matters, the Constitution does not make it clear to which extent matters can be decided on by arbitration. So as I said earlier, arbitration does not cover criminal matters, right? But then again, the Constitution does not necessarily say, okay, in the other areas in which arbitration can cover, like what extent, what is the limitation of arbitration? Like what is the limitation that arbitration can cover? So we just know that arbitration cannot cover criminal matters, but we do not know what extent to which matters can be covered by arbitration. So that thing not being very clear holds some kind of limitation. And then enforcement of arbitral awards requires the court to enforce it. Okay, so arbitral awards are basically the awards that are granted at the judgment of arbitration. And arbitration cannot be excluded from the court, because at the end of the day, even if a judgment is awarded in arbitration, you still need to go to the court to enforce that judgment. And then arbitral award is only binding on the parties to the dispute. So arbitration awards, as I was explaining earlier, is just binding on the parties to the dispute. So there's no third party involved. It's not like, let's say, open court where a judgment is being made now. A judgment has been made. It does not become a precedent. It doesn't become a legal precedent. It just stays between the parties involved and their business. Basically, this is the judgment made for these parties and it ends there. If a similar matter comes later on, they cannot refer back to that particular judgment and be like, oh, look at what they judge concerning this particular issue. Why don't you, it doesn't work that way. And then arbitration requires both parties' consent before commencement. So arbitration law, basically, the parties involved have to agree that they want to do arbitration. You cannot do arbitration with just one party. The both parties have to come and agree that, okay, we want to do arbitration for it to even commence at all. So limitation in Nigeria. Okay, I've already explained constitutional ambiguity. So there is no clear extent to which IP can be arbitrated, and then underdeveloped framework. So in Nigeria, IP arbitration is still evolving, is still in the infancy state, essentially. So there are limited, specialized tribunals for IP arbitration, unlike, let's say, in a country like US that has specialized IP arbitration centers or detailed rules tailored for IP dispute. Nigeria does not have that yet, so it is quite a major limitation in Nigeria. Okay, so to sum everything up that I just said, IP enforcement is the protection of IP rights to prevent or stop infringement, which can be enforced through physical and online means. And it has challenges which are currently facing enforcement of IP rights, like diverse IP laws, among others. And now arbitrability of IP disputes brings to question whether those disputes can be resolved by arbitration process. So although arbitration does not have the authority to handle criminal matters, there is still a question of to what extent can arbitration be relied on in disputes. But all in all, it's still a very fast and swift, efficient process to resolving IP disputes. So thank you very much. I am done with my presentation.
All right. Thank you so much for that very wonderful presentation. Please can you kindly just tell us your name? I don't think you did that at the start of the presentation, so that at least we get to know you.
Okay, my name is Ewomazino Iwo.
Okay, Ewomazino. Okay, thank you so much for that presentation. I did not want to try to pronounce it so that I don't murder it from my own side, but thank you all the same for a very wonderful presentation. Well done to you and to your team members for putting together your presentation. It was well received and well delivered. So once again, a job well done to everyone involved in the preparation. So I don't know if group one is ready right now with their presentation. Please, group presenter for group one, please, you can try again, right? And let's see if we can get your presentation.
Good evening, everyone.
Yes, good evening. Please, your name, we can't necessarily see your name. So please, can you just kindly tell us your name and then start the presentation?
My name is Ajibade Naimat Adeola, and I'll be presenting for Group 1 on registration and infringement of intellectual property. Although I'm having problems sharing my slide from here, but I think the group leader will be able to do that very soon.
All right, please, group leader, I'm having a little issue with my PowerPoint app, so application, it's a little bit difficult doing that also from my end. So please, you can go ahead. We can see your screen.
Can you see my screen?
Oh, it has disappeared again. So my screen has this Microsoft label on it, so I can't seem to undo it or remove it. So we may need help from someone else within the group. Please, can we have someone else within the group help out with sharing slides? Can we please quickly do that?
It's saying from my end that only the host can share the screen.
Okay, I'm coming. Let me see if I can. Okay. I can see as it says.
Sorry, sir. Can you see my screen?
No,
It's
we
not
can't.
showing.
Okay.
All right, can you try again? Yeah, so your screen is up, right? We can see it, but we cannot see the presentation yet. All right, so we can see your screen now. Please, Neymar, you can go ahead and start your presentation.
Okay, thank you very much. Sorry about the delay. So, without wasting much of our time, I'd like to continue from what IP registration exactly is. As we've learned what intellectual property is all about from our previous mentors, from the previous classes. So, what is intellectual property registration? Intellectual property registration is the legal process of applying to the relevant authority to obtain official recognition of right over an intangible asset. So, for intellectual property registration to occur, there must have been an application to the relevant authority in order to obtain an official recognition of right over an intangible asset. Now, what are the levels of intellectual property registration? Intellectual property registration can be divided into 3 levels. The first one, regional registration, national registration, international registration. Can I proceed?
Yes, you can.
Okay, so for the regional registration, we have ARIPO, we have OAPI, and we have European Union System. ARIPO is an abbreviation for African Regional Intellectual Property Organization, and it's for the English-speaking African countries, while OAPI is African Regional Intellectual Property Organization also, but it's coined from a French word. So, but it is meant for the French-speaking African countries. So Nigeria has not joined any of the regional registration. Nigeria is not a signatory to ARIPO, neither is it a signatory to OAPI. But whenever Nigeria wants to become a signatory to any of the above regional registration, they will probably join ARIPO because ARIPO is for the English-speaking countries. So we also have national registration for IP registration. National registration are those that are within Nigeria, like the statutory provisions that is required for registration of intellectual property in Nigeria, and they are mostly 5. The first one is the Copyright Act, the Patent and Designs Act, the Trademarks Act, the Merchandise Marks Act, and the last one is Company and Allied Matters Act. The copyright protects the literary, artistic, musical, the cinematographic works, while Patent and Designs Act is for industrial designs and inventories. Also, Trademarks Act, it protects the registered trademarks, while Merchandise Marks Act protects business, it criminalizes certain acts relating to fraudulent marks on merchandise. Also, the Company and Allied Matters Act, it regulates business names in Nigeria. So moving on, we have the international registration systems. We have MADIT system, we have PCT, we have age system, and we have Berne Convention. Under Madrid system, we have Madrid Agreement and Madrid Protocol, and they are the ones that regulate international registration of trademarks, so that any trademark that has been registered in any country that is under this agreement will be protected in all other countries that are also registered under this agreement. Now, we have PC, and is a mechanism administered under WIPO, World Intellectual Property Organization, and it makes it possible for inventors to register their invention through a unified system. We also have Hague system. Hague system is also an international mechanism that is administered by WIPO to protect industrial designs and worldwide through a single chain. And the last one, Berne Convention. Berne Convention is also an international agreement administered by World Intellectual Property Organization, WIPO, and they ensure that works created in one member country enjoy copyright protection in all other member countries, with the need for formal registration, of course, in those countries. Now, what are the procedures for registration of an intellectual property right? So the first step, we have search and clearance. Of course, these are different from each other, but most times they tend to correlate. For example, copyright and trademarks, the procedures that are necessary to follow before registration can occur. That's what I'm trying to explain. So the first one, search and clearance. So for search, the relevant authority must have conduct a search in relation to it with existing rights. While step 2, application filing. Anybody that wants to register their intellectual property has to file an application with necessary details that are required to be done to check if such person that to register their rights have comply with. So after all these processes are followed, the next thing to do is such application in an official gazette. The wants an opposition or okay. In the next, anybody that wants to raise an opposition will then raise an objection, and such objection, for example, in trademark, must be raised within 2 months after the publication has been made. And after that 2 months, notice of such objection will be published. Then the next step 6, registration and certification. If no objection, then the next thing is for the authority to register such intellectual property like trademark or copyright. Furthermore, we move to IP infringement. So what is IP infringement? What exactly do we mean by intellectual property rights infringement? So IP infringement is the unauthorized use of a creation or invention that is protected by IP law, such as patent, trademark, or copyright authorization, of course. So what are the forms of patent infringement, trademark infringement, counterfeiting? We have piracy, we have plagiarism, online piracy, and etc. So to put it simply, we divided forms IP infringement into 2 forms, which are the physical infringement and the online infringement. the physical infringement is one that is done with regards to an IP that is protected physically. For example, counterfeiting of goods, knockoffs of brand, unauthorized copies of like literary text. While the online infringement is one that occurs within the digital sphere, and it involves the unauthorized production or distribution, and it involves the unauthorized use of another's IP's right within the digital sphere. Now, example of, we have piracy and we have counterfeiting. Although piracy and counterfeiting are mostly used interchangeably, but they have slight differences. So the difference is that piracy is the unauthorized reproduction and distribution of copyrighted works, which amounts to violation of the right of the holder of such copyright. It is when another person uses another person's copyrighted work and it amounts to violation of such holder copyright. And it concerns, this is the major difference between the two. It primarily concerns creative and artistic work, such as music, movies, software, and literary works, while counterfeiting concerns the brand name. Like, it is when another person use or mislead consumers to damage the reputation and goodwill of another person's brand that has been registered under trademark. So an example of counterfeiting is the case between Gucci and Guess in 2009. In that case, Gucci was a high-end fashion. We all know Gucci. It was a high-end fashion brand, while Guess is just a fashion retailer. Gucci sued Guess and alleged that Guess was using several Gucci's trademark designs, including their iconic diamond G pattern. They claim that this use of their diamond G pattern has confused their customers, and they claim for $200 million. The court ruled in their favor, although they didn't grant the amount to Gucci completely, but the court ruled in their favor and awarded a smaller amount of damages to them. Also, the example of pirating is it can be seen in the case of music industry versus Napster, whereby the Recording Industry Association of America, they sued Napster for contributory and vicarious copyright infringement because Napster facilitated the illegal reproduction and distribution of their copyrighted music. The court ruled in their favor and fined Napster liable for infringement of music industry limited right, because they had the knowledge of the infringement, and they could have prevented it, but they didn't. Therefore, the court ruled in favor of music industry. So moving on, we have the enforcement and remedies for IP infringement. So the civil remedies are the damages, injunctions, destruction of infringing goods. While criminal remedies, we have fines, imprisonment for infringement offenses. What's the goal for these civil remedies and criminal remedies? The goal is to protect creativity, to ensure fair competition, and to encourage lawful creation. In conclusion, IP registration not only secures rights of creators, it also enforces and it also aids the enforcement against infringement, and it upholds IP vital for innovation, for growth, and for fair competition. Thank you very much. That will be the end of the presentation.
All right. Thank you very much, Neema, for your very wonderful presentation. I don't know if it was just me, but at some point your voice was breaking, but we were able to still follow up with your presentation. But thank you all the same. Thank you also to Azizat for helping share your slides. We really do appreciate. Well done to you and your team, and to the members that contributed to putting up the presentation. Unfortunately, right, we will not be able to have our other two mentors in today's session. That is Mr. Sand and Mr. Folarin. Right, but we trust that Mr. Marks would be able to help us just speak to share his other points or thoughts on this subject matter as we continue in the discussion for today's topic: IP infringement, registration, and enforcement. So, Mr. Marks, over to you, sir. We would want to get your feedback on the presentation.
Okay, thank you, Dennis. Please confirm you can hear me.
Yes, sir, we can hear.
Okay, thanks so much. Yeah, let me start by commending both groups for your very detailed research and the slides you prepared. I think it's quite encouraging to see that you guys are truly getting the gist of what IP is all about. So I commend both groups. I'll just make a few observations and maybe just some additions to your presentation. So I'll start with group 2. So I commend Womazino, right? You did a great job. Well done with your presentation. I like particularly that in treating enforcement, you went beyond the traditional modes of enforcement, because we all know that the traditional modes of enforcement typically is with a court action and, of course, administrative action. And, we also now have increasingly the fact that IP infringement now is no longer a physical activity. It has become in fact, main IP infringement now takes place online. So there's a need to look at the emerging area of enforcement online. And then I was also happy particularly that you highlighted the use of ADR, alternative dispute resolution, such as arbitration, to resolve IP disputes, and in that sense enforce the IP rights of parties. So I'll just say a few things about. Let me start with online infringement and online enforcement. So, like I mentioned earlier, increasingly the hot spot where IP infringement takes place now is online. So it starts everywhere from even, from apart from infringing websites. We talked about Napster. Napster was a very popular online platform. They had a couple of them in those days. They used to call them P2P networks, peer-to-peer networks. So the way they functioned was that if I have different music on my system, and Dennis comes online and he wants to download that music, he won't go to the to the owners of the music in terms of the recording label and all of that. He comes online, he connects to that software, Napster, or there's used to be another popular in this called DAP. He connects to it, and then he searches and requests that he wants to download XYZ music. The Napster service, because I'm also a subscriber to Napster, would have checked the catalog of all the music on my system. And then if that song is there, it picks it from my system and gives to him. Same thing, if I also want music, it picks from another person's system and gives to me. So you can see that those services were essentially undercutting IP, particularly copyright holders in music. So, they needed to launch a very serious war to bring Napster down. But of course, in recent times, we are seeing new modes of infringement online. AI has become another huge infringement vehicle at the moment. So I'm sure most of you follow IP news would know that just, I think, last month, the US court had given a very important judgment that the popular AI app called Cloud.ai, produced by a company called Anthropic. So what had happened was that when the Anthropic wanted to train the cloud.ai model. What they did was that they went to websites where pirated books are sold and then bought, just bought all the whole catalog of books on that website. So it was all those books that now fed into the system and used as part of the training data to train the AI. Now, the authors and publishers sued them, but they couldn't sue them directly for copyright infringement. And that is because the US Supreme Court had given a judgment, I think in June of this year, that using copyright works to train AI is not copyright infringement. The reason being that under US law, there's an exception for what they call transformative use, that is you can use as a defense under the defense of fair dealing. What it simply means is that even though I took your work, I did not simply copy your work and use it directly. I transformed it. I put some effort of my own on that work to create something new and unique. So therefore, I'm not infringing on your work. So because of that, the people who sued Cloud.ai could not sue directly for copyright infringement. What they sued for was that the books were gotten from pirated sources. So that was the basis on which the court awarded judgment. So that's just to show you, how AI, IP infringement, in the online world now with AI and all, there's, a whole new set of issues that come up, on those platforms. I also commend Group 2 that you also mentioned, yes, that many online marketplaces and social media sites like Facebook and that, they have what they call, essentially a copyright notification system embedded, and other IPs, even trademark and all of that as well, where you can flag infringement and you can actually get what they call a takedown. You can get them to take down, and if the infringer is a repeat infringer, at some point they'll shut down their account or terminate their account. Like YouTube will shut down your channel or sometimes freeze the channel or suspend it for a while, just to call your attention to the fact that your channel has become a source of infringement. So it's also important to know that under the Copyright Act 2022, Nigeria also has created a proper copyright takedown system, domiciled with the Nigerian Copyright Commission. Of course, the effectiveness of it is another question, because at the end of the day, how takedown notification works essentially is that it is the government of the jurisdiction where the IP internet service providing companies are hosted that really have the authority to enforce. So because of that, globally in the world, one of the most important online systems of IP enforcement is what we call the DMCA, the Digital Millennium Digital Millennium Copyright Act. Is a law passed in 2000 in the US that now says that any internet service provider who is hosted from the US, if a person complains to you that there has been an infringement of their copyright on your website, then you must put together a process to check, confirm if it is true, and then you must take down that infringing website or infringing article off of your platform. So if you do that, you are entitled to what they call safe harbor. Safe harbor simply means that if, as an internet service provider, you are actively doing your work of ensuring that infringement does not happen on your platform, you are therefore immune from any copyright IP infringement action that is brought against you. So what it simply means is that if somebody is infringing my products on Facebook, we know that by normal law, by the normal principles of law, I can sue the person who is infringing. I can also sue the platform, Facebook, as well. But what the DMCA law does is that it says, look, if we allow people to sue the platforms, because the platforms are not the ones who come up with that content, it will become an issue and it would, ground the development of the internet. So therefore, we will tell platform owners, if you will be diligent to ensure that you do not allow infringers use your platform, then you'll be protected from anybody suing you. So you can only sue the infringer, you can't sue the platform. So Nigerian law also, essentially, I'm saying, currently has that provision. I'll just tell you that whether it is effective is another problem, because many internet service providers are not hosted in Nigeria. So there was a time I actually tried using the Nigerian system. I wrote to the Nigerian Copyright Commission, hoping that they would be able to write on our behalf to some of the platforms hosting those infringing materials. But it was difficult to get the Copyright Commission to act. Even when they did act, those platforms are not even ready to listen to them, because I mean, you really can't enforce against them because they are not based in Nigeria, and the Copyright Commission doesn't have any right over them. But that being said, for Nigerian hosted websites, like websites that are under the .ng, the top domain name for Nigeria, which is .ng, for those kinds of websites, they are all hosted by NIRA, the Nigerian Internet Registration Association, and the NIDA, Nigerian Information Technology Development Agency, has oversight over them. For those kinds, the Nigerian takedown provisions under the Copyright Act 2022 would be quite effective to use as an enforcement tool against them. I think the only other, then a few other things I want to add to Group 2 also is that Group 2, yes, you were right in mentioning that you can also use administrative procedures like the customs. Very important, particularly for infringement that is coming through imports. So if you get wind, for instance, I've had a situation before where my client, a publisher of textbooks, got wind that some schools in Nigeria, rather than buy books from him, took the sample of his books, sent it to a printer in China, mass-produced the books, and were importing them into the country. So the moment he got wind, we went to the Copyright Commission, did a voluntary deposit of his textbooks, got the copyright certificate. We wrote to customs and alerted the customs. We were also able to even get as much information, including the consignment, the ship and the consignment numbers on which the pirated books were coming in. And the customs actually seized those goods at the port, and gave us enough time to now get a court order, and also got an order to forfeit those books as well. So customs measure also works very efficient for import-related infringement as well. Another government agency that for a while also has worked quite effectively for enforcement of IP rights is the Federal Competition and Consumer Protection Commission. So you can also report to them, because in a sense their mandate is wide and involves even unfair trade practices, of which IP infringement is one of that. And in those days, we were able to get them to act for us very fast, to go to a warehouse and seal up the warehouse when we suspected that they were infringing goods in that warehouse. And the reason was because the other option is for you to go to court and get what to call an Anton Pillar order. And an Anton Pillar order is a kind of injunction that authorizes you to a search and seizure, to go into a premises, search the premises, and seize any infringing goods. But sometimes we know how the courts can take a long time to process that. So sometimes the FCCPC can be a lot faster, even though lately we have noticed that the FCCPC has become reluctant to be used for purely IP disputes. So they will usually insist that, except to show them that there's evidence of counterfeiting and contraband and pirated items. But if it's just a normal, maybe trademark infringement matter, they are usually reluctant to act. And then there's another thing they do now, which is quite helpful. They would insist that if they must act on your behalf, then you must give an undertaking to the commission that if they act on your behalf and seal up or take any action, and the third party takes them to court, then you will undertake to pay their legal fees and also to indemnify them if damages are awarded against them. So that's, in a sense, protecting themselves in the event that maybe you come and lie to them and make them, because that happened to them from experience. Somebody came, lied to them, got them to go and seize another person's products, claiming IP infringement. And ultimately, when the matter went to court, the court found that there was no IP infringement and awarded damages both against the commission and the party that sent them to do that. And of course, by that time, that person who instigated them to do the IP enforcement had already run away. So sometimes, that's what you find with administrative process. So sometimes also you can use NAFDAC for an IP infringement where you have registered your goods with NAFDAC, like I told you, and you have registered your trademark as well. And somebody is also trying to sell those same goods. You can also get NAFDAC to take action and seize such infringing goods as well. So administrative process also is very efficient because the court route sometimes can be prone with trouble. You can get a judgment and the person appeals to the Court of Appeal, appeals to the Supreme Court, and the case takes forever. And in all that time, your business is running down because the infringer continues to infringe on your IP. So I'll just wrap up on group 2 with a few thoughts. Group 2 was mentioning that there's a constitutional ambiguity about enforceability of IP rights using arbitration. So yes, there's actually an issue with that, and I'll explain that. Now, what you need to understand is that IP rights are granted by the government of the country under its public policy considerations. So an arbitration panel, like Group 2 mentioned to you, is a private dispute resolution mechanism. Unlike the courts are public dispute resolution mechanisms that are funded by the government and are a part of the government bureaucracy. But the arbitrator is a private individual who both of you agreed beforehand to submit your dispute to. So you go to him and he gives a judgment. So the thinking before now was that government said, look, how can a private dispute resolution process now give a decision that is binding on IP rights that were granted by the government out of public policy considerations? For instance, patent. The government is concerned that in granting patent, they want to reward and incentivize further research and development of new inventions. So the question is, why should an arbitrator who is a private party be entitled to give a decision on the validity or otherwise of a patent? So that is the basis on which many countries say, look, you cannot resolve IP disputes through arbitration. But however, it's important to note that there are distinctions. So some countries, for instance, allow arbitration to resolve any type of dispute, any type of IP dispute, irrespective of the subject matter of the IP dispute. But what you need to understand is in Nigeria, and the general consensus is this: IP disputes that are concerned with the commercial terms negotiated between parties can be resolved through arbitration. I'll explain what that means. But what an arbitrator cannot do is to pass a decision that affects the grant or the validity of the underlying IP right. So let me explain that. If I have a franchising agreement with Dennis, and part of the franchising agreement is that I have licensed him the right to use my trademark to start up maybe a branch of my eatery in Lagos, for instance. Now, that franchise agreement is a commercial agreement between both of us. So if my dispute with Dennis is that he used my trademark in a way that I did not like, that's the commercial problem between the two of us. I'm not calling on the arbitrator to decide whether the trademark is valid or not. So those kinds of disputes that are contractual or commercial in nature, you can use arbitration to resolve them, including the IP aspects of that dispute. But where, for instance, I give Dennis the right to use my patent, and then he goes to use my patent and he does something and I sue him, and his argument is that that patent is not valid, then in that case, what the arbitrator is called to determine is the validity of the patent, which was granted by government under public policy consideration. Now, that would not be subject to IP. So that's a distinction. So then I'll just make a clarification that Group 2, in your presentation, you mentioned that there's uncertainty as to what can be resolved by IP. That's not really the case. What can be resolved by IP? The simple test by arbitration, the simple test to know what you can resolve by arbitration is what we call accord and satisfaction. So any civil matter that you can resolve by giving somebody something in consideration for him to accept a resolution of that dispute, that's what we call accord and satisfaction. Those kinds of disputes can be resolved through arbitration, excluding, of course, criminal matters like Group 2 rightly mentioned. So the scope of what can be arbitrable, that is in arbitration, is called arbitrability. the scope of what is arbitrable is very clearly defined. It's not an area where there's much difficulty. Once you know arbitration, you know exactly what can be arbitrable and what cannot be arbitrable. So there are things that public policy exempts from arbitration. For instance, taxation. You cannot resolve tax disputes through arbitration. And then there are other areas as well where you can, criminal matters and all of that, matters that involve status. For instance, legitimacy of a child, marriage and divorce and all of that cannot be resolved through arbitration. Then also group 2, I think group 2 also mentioned at the point that you were wondering if Nigeria has whether Nigeria has robust arbitration rules and the setup. I want to say yes, Nigeria does. Maybe not as robust in the area of intellectual property arbitration as it should be, but notwithstanding, we have a lot of new arbitration institutions in Nigeria that have very qualified IP professionals. For instance, the Nigerian Copyright Commission and the World Intellectual Property Organization set up an arbitration and mediation system in the Copyright Commission that now resolves IP-related disputes, and they have very clear rules governing the procedures, and they are doing a great job. So yes, Nigeria at the moment has a robust arbitration setting for resolving IP disputes. And then for group 2 also did group 1, sorry, that's Nahimat, I believe, also did a great job. I particularly enjoyed the case studies you used. I mean, case studies always make these things come to life, and I'd already commented on the case of Napster that you mentioned and how suddenly we are back to that issue of Napster again with the AI companies taking people's copyright works and using it to train their artificial intelligence machines as well. Then group 1 said a few things about international registration of IP, which is very important. Now, one of the things you need to understand is that there's technically nothing called international IP. That means you cannot have an international trademark, nor can you have an international copyright or an international patent. However, like Group 1 mentioned, there are instruments through which you can register an IP right in multiple jurisdictions using those specialized mechanisms. So it doesn't necessarily mean that the moment you use the Madrid system to register a trademark that you now have an international trademark. No. What the Madrid system does for you essentially is that it allows you use one uniform set of processes and procedures to register your trademark in multiple countries at the same time. But at the end of the day, your trademark rights would still be territorial. That means it is every country you designated in your registration process that will now give you individual protection in their country. Same thing also, Naimat also mentioned the PCT, the Patent Cooperation Treaty, which is also an international system that you can use to register your patent in multiple jurisdictions at the same time. So it's also important to be right. But then, of course, apart from those ones, we also have the regional systems. Like I believe Naimat also mentioned the ARIPO, which is a predominantly Anglophone speaking union of African countries, about I think 18 or 19 of them now, that will allow you gain IP registration in all their countries using one set of application. We also have the ORP, which is more of a francophone based system. The difference between ARIPO and ORP is that in ARIPO, when you register your IP right in ARIPO, you still have to designate each country individually and then go and then you'll be given a protection separately by each country. But in ORP has a unitary system. It means that the moment you register your trademark in the ORP system, automatically you get protection in all the 16 or is it 17 member countries of the ORP system. The European Union patent system also, European Union Intellectual Property Office also offers the same kind of unique regional system where you can do a registration with them and automatically get your IP right protected in all the 26 now, with the UK out of them now, 26 member states of the EU. So, and then there are a few other systems also that operate like that. So it's good to just know that, yes, you can, when people tell you about international, I want to register an international trademark, you need to just educate them that, well, yes, you can. There's an international system that allows you to register a trademark in multiple countries, but technically that doesn't make your trademark to become an international trademark in that sense. So these are just my comments and additions to your wonderful presentations from both groups. So again, I commend both groups for your very wonderful and insightful presentations. So thank you, Dennis. Let me come back to you.
All right, thank you so much, Mr. Max. I don't know which I enjoyed the most, your first discourse or your feedback and further contributions that you gave, highlighting both what was happening within the presentation of Group 1 and Group 2. We really do appreciate your shared experience. From everything I could pick up, right? This was what you shared was not just textbook experience or textbook knowledge wise within the confines of registration, infringements, and enforcement, but also practical and situational experiential knowledge that you shared with us that you have gathered over through the years of your very vast experience within the IP space. And we want to say a big thank you, sir, for your shared thoughts in class today. So I don't know about you guys, but I'm sure we have all learned quite a lot from Mr. Max today, right? So please, before we take questions, I really want us to just appreciate Mr. Max for everything that he has shared in class today. So please, by use of the emojis and, by clapping emojis, can we just show our appreciation to Mr. Max Ikombe? Do we have mentees in class? All right, thank you. So what we'll be doing now is that we'll be taking questions, right? So please, if at all, it's been over an hour plus, right? And it has been quite exhaustive, right? A lot has been shared, a lot has been said, right? It's very detailed things have been said and shared. So please, if at all you have any questions, we can take, I think, 3 or 4 questions, right? You can go ahead, raise your hands, and I'm sure Mr. Max will do well to accommodate our questions and also help answer them. So please, if you have a question, you can indicate by raise of hand or send your question into the chat box. Do we have questions in class today? I really do hope that we do have questions because quite a lot has been said, right? Do we have questions? Okay, so I want to assume that in everything that Mr. Max said, and based off of research and, overall throughout the week, right, we have not come up with any question. I think the question that was sent to the group, I think it was a question that was sent during the presentation was a question that Mr. Max addressed. So I did not see the need for posting it again. So, well, if we don't have any question, right, then we will take a
Dennis, I can see
a
question in the chat
before calling it.
Okay, hello, Dennis, can you hear me?
Okay.
Yes, I see a question in the chat. And I also note that our grand mentor, Folarin Aluko, I just noticed I got somewhere, I think he's with us now as well. So maybe I'll take this question and then I'm sure you'd want to bring him in. Let's get some thoughts from him as well.
Oh, all right.
Yes.
Thank you very much.
So I see the question from
yes, sir, you can go ahead and answer.
Oh, okay, thank you very much. So I see the question from Olua Kemishola. She says, I didn't understand the part where he said arbitration may cover some part of IP. I don't know if I got that. Okay, so let me explain that again. Now, so like I was saying, the reason why there's a challenge on whether arbitration can be used to resolve all kinds of IP disputes stems from the fact that an arbitrator essentially is a private dispute resolution mechanism, and the question is that IP rights are essentially, tools of public policy that the government is using to regulate its own its own nation. So, for instance, the underlying policy consideration why patents are granted is to ensure that the government is able to incentivize research and development and innovation. So the question is, would in that scenario, the government may not be happy for a private arbitral tribunal to be the one to now decide on questions around the validity, the enforceability of IP rights. That is actually reserved to the courts. So so initially, before now, the thinking was that once IP features at all in a dispute, automatically the arbitrator cannot even touch that dispute. The initial arguments were that under the Constitution, Section 251 of the Constitution gives exclusive jurisdiction over copyright, trademark, patent to the Federal High Court. Therefore, the arbitral tribunal cannot take away from that exclusive jurisdiction by resolving those disputes. However, that has been shown to not be exactly the case. The reason being that there are so many other commercial issues that are also in Section 251. If you say everything in Section 251 only belongs to the Federal High Court and arbitrators cannot handle them, then it means that oil and gas disputes cannot be handled by arbitration tribunals. It will mean that almost every commercial type of dispute cannot be handled by arbitrators. So the understanding is that it is not simply because the Constitution gives that right. What lets you know when you can handle, when arbitration tribunal can handle or not, is the nature of the order that the arbitrator is being asked to make. If the arbitrator is simply being asked to, to make orders about, a commercial dispute between parties or contractual elements of their dispute. So, for instance, I give the example of a franchise agreement, or let's even say, for instance, between a music label and the artist. If there were disputes, between the two of them, if they relate to the fact that you did not pay me for this show, you did not pay me for that, you published my my music catalog, you did not give me my own share, and the copyright in that music catalog belongs to me and all of that. You can see that the arbitrator is not being asked to determine the validity of the copyright. He's only being asked to determine damages that would flow from the use of the copyright. In those scenarios, because it's just a commercial dispute, the arbitrator can handle it. But where the arbitrator is being called upon to give a verdict on, for instance, the validity, the enforceability of an IP right, that is where the arbitrator is going to now run into a public policy roadblock, that he cannot, being a private tribunal, make public policy decisions concerning the underlying IP right. So I give the example as well, of course, for instance, in patent, because in a patent litigation, you need to understand that under the Nigerian patent system, our patents are not substantively examined. That means before your patent is granted, the Nigerian Patent Registry does not carry out an examination to confirm that the patent is indeed novel and all of that. Once you fulfill the formal requirements, your patent is given to you. It is only when you go to court that the argument of whether this patent is valid, was this, at the time of registration, was it novel, and all of that, that is when those questions will come up. So what we are saying is that an arbitrator cannot answer those questions, because those are public policy questions on whether that patent is valid and whether that patent is enforceable. The arbitrator cannot answer those kinds of questions. That kind of dispute, can only be resolved at the level of the court. And this all come under the question of what we call arbitrability in the law of arbitration, that governs what an arbitral tribunal can resolve and what they cannot resolve. So it just tells you that when you have a dispute, the fact that IP is mentioned, that dispute does not automatically mean, therefore, that arbitration cannot resolve it. Like I also told you, the Nigerian Copyright Commission at the moment and WIPO, they've set up a very robust ADR mechanism for resolving disputes in the entertainment and copyright-related industries, and it's currently flourishing and functioning very well. But in some countries, for instance, in Switzerland, arbitrators are allowed to resolve even disputes that border on validity and enforceability of underlying IP rights, such as patents and all of that. But in Nigeria, because of our common law heritage, there's that limit that no, you can only resolve commercial and contractual disputes, but you cannot resolve disputes that border on the public policy elements of the underlying IP right. I hope that explanation helps to put the matter in proper context. Thank you.
Yes, sir. Thank you.
You're welcome.
All right, thank you so much, Mr. Max. So we still had a few more questions come in. I think 2 more. I don't know, sir, if it's possible to quickly just give context to those questions before we move over to Mr. Polarin.
Okay, thanks.
Hello,
So I see IP. Can you hear me?
Yes, I can hear you, sir.
Yes, so I see a question from John Adelabu. Can you briefly explain the concept of passing off in IP? So passing off is not even necessarily an IP stuff per se. It's just a normal law of, principle under the law of tort. So we know that the law of tort, as opposed to the law of contract, the law of contract contract simply means both of us enter into an agreement, and in the course of carrying on that agreement, I do something that harms you in the course of carrying on that contract. But however, a time came where the law now said it is possible that we do not have an agreement, there's no contract between us, but I have done something that harms you. So in a sense, not exactly a criminal matter, but a civil matter. That means I've done something that has caused me some sort of damage or discomfort. So that's where the law of tort arose from. Of course, we know for those who are lawyers here, there's a popular case called Donoghue and Stevenson, where somebody went into a bar to have a drink and opened a bottle of soft drink, and then I think a dead cockroach or something was inside the bottle. She drank it, fell ill, and then sued the company. And the company said, well, there's no contract between me and you, so therefore you cannot sue me for harming you, because it's not as if we had a contract and I defaulted on the contract. But the court said no, that there's a common duty of care that you owe any third party who will come in contact with you. So it is out of that principle that you need to take care not to harm any other individual that the law of passing off arose from. So passing off as a tort simply means that you have used another person's reputation and goodwill to market your own products and pretend that those products are that of the person who has spent time, money, building his goodwill and brand reputation over time. So you can see that it is similar to trademark, but it's not exactly the same with trademark, because in an action for passing off, you have to prove that you have invested in building the goodwill and the reputation of that brand, and that the other person has tried to use that reputation and that brand to sell his own products without your permission. But if it was a trademark infringement, there's no talk about reputation or any of that. The moment you bring your trademark certificate, my trademark is called Coca-Cola, and this guy has gone to now produce a soft drink and call it Coca-Cola, and is use the same color, brown and all of that, and people buy Coca-Cola thinking it is Coca-Cola. The moment you present that, you don't have to start showing what effort you have put and all of that. Instantly, the moment the court looks at the word Coca-Cola and your trademark certificate Coca-Cola, once it is similar or confusingly similar, automatically the court would hold that there has been a trademark infringement. But if it was a passing off action, it would not be exactly automatic. You have to still go ahead and prove. You have to start bringing, for instance, you have to bring your revenue, your advertisement spend. You have to show that in the last 1 year, we have spent over 100 million on adverts. We did placements of billboards. You have to bring receipts from the your advertising agency. You have to bring evidence to show that we won an award as the most popular soft drink at the Nigerian Merit Award. You have to bring evidence that Pediatric Association of Nigeria endorses our product as a good and safe product for children. So you have to bring a lot of things to show that you have invested in building the goodwill and the brand of that, the brand, of that product, and that the other person came and stole that brand and goodwill and used it to market his own products. So that's the difference between passing off and trademark, even though they are similar, but they are not exactly the same thing. They both come from different sources of origin. Of course, it's also important to note that at the end of it all, intellectual property infringement actually is also a type of tort. So an action of intellectual property infringement is also an action in tort, just the way passing off is also an action in tort. But then there are some differences between the two concepts. So John, I hope that answers your question very well.
Yes, thank you, sir. Thank you, sir.
Okay, you're welcome. Then I think the last one I see, Dennis, is Oni Bukola says, how do you resolve the matter when the infringer is a foreigner? Which court will oversee the case? So now that's a very important question and comes back to the issue we mentioned about, in quote, international intellectual property rights. So intellectual property rights, like I mentioned, are not international. So it means if I register my trademark in Nigeria, I'm only protected in Nigeria. If somebody goes to Benin Republic and takes my brand name there and begins to market his own product, I cannot go to Benin Republic and sue him. Neither can I sue him in a Nigerian court for the action he took out in the court in Benin Republic. So one of the options is that I would have to now go as well to Benin Republic and register my product there. But I mean, imagine if the product is a product that I'm hoping to sell to many countries, then it means that the primary clumsy way of getting protection is to go to each country and register my trademark individually in each country. Of course, the smarter way we have mentioned is you can use the regional system. So for instance, if I want to market my product in Africa, I can go to the ARIPO, register in ARIPO. ARIPO gives me protection in about, I think, 18 or 19 mostly Anglophone speaking countries. So Kenya, Zimbabwe, Zambia, Ghana, and a lot of other English speaking African countries. I can also register in the OAP. The OAP is mostly Francophone countries, so Cameroon, Cote d'Ivoire, Senegal, and all of that. So I also register there. So if I can register in those two, it means that I've already covered somewhere around 35 out of the 51 African countries. I can also register in the EU Intellectual Property Office, EU IPO as well. That gives me protection in about 26 countries. Of course, I could also use the Madrid system to register in many of those countries. That would now give me the right to go to his country if I registered it there, to brief a lawyer there and sue him there. Now, of course, if the foreigner comes to Nigeria to come and infringe on my product, like the example I gave you of the client who was doing textbooks and somebody went to took his books to China, had them mass produced and were importing them back into the country. Even if he's a foreigner, once he steps in Nigeria and he tries to do it in Nigeria, then of course I can sue him before the Nigerian courts or using the Nigerian administrative mechanisms like the customs, the Federal Competition and Consumer Protection Commission. I can use any of that against him. But if he's doing it in his country and has not registered in his country, then there's not much you can do. Of course, there are some covers like what we call very popular, very well-known marks. So very well-known marks, even when they are not registered in the institution, still have some level of protection. So for instance, if somebody is trying to register a trademark for Coca-Cola in Nigeria, even if Coca-Cola is not registered in Nigeria, they would have a right to raise an objection and say, look, we are a well-known mark, and this person is just trying to steal a mark. But again, the best option remains that if you want full protection, then you have to get your product registered in each of those markets you hope to market to make your products available. So, Bukola, I hope that answers your question.
Yes, sir.
So
Thank you so much, sir.
Thank you, Bukola. So then it's back to you.
All right. Thank you so much, Mr. Max, for helping us answer all our questions. We really, really do appreciate the time you spent in trying to break down the concepts and the questions that were asked you. We really sincerely do appreciate Mr. Max. So, Mr. I think we'll just, before we just round up for today, right, we'll just be giving the floor quickly to Mr. Polarin. Mr. Polarin Aluko, thank you so much, sir, for joining. We are happy that you were able to squeeze in a little bit of your time to still join us. We are happy to have you in today's session. So our topic for today and what we have treated in class has been IP for IP registration, infringements, and enforcements. I don't know if there are any little thoughts you would like to share just before we close, as a closing thought to just finally wrap up the session for us. So, Mr. Polarin, over to you, sir, if you have some thoughts you would like to share with us, sir.
Good evening, and my apologies for joining late. Whenever, as a bad student, I was told that whenever you come late, you stay at the back of the class. You shouldn't go to the front of the class. So I would happily stay at the back of the class. Earlier on, when I joined, I heard Uncle Max breaking down some breakables, and I would say that I think he's done a fantastic job of breaking down all the concepts. I didn't catch any of the presentations, but I did go through some of the. I did go through, I think, one or two group slides. So I would say well done. I think Max really, Uncle Max. That's part of the conversation that I caught up with. Has really covered the field. So I would say well done to everyone. Industry is very important, especially in this space. There's so much to know, and of course, it's not just about knowing it, because this stuff is very practical and is real. So you're in the right place. Well done, and I think from the questions that were asked to, very fantastic questions. They clearly show that mentees are thinking. I would also maybe, I didn't catch the presentation, so I would encourage you to in preparing for your presentations, to explore to consider approaches from jurisdictions like Kenya, South Africa, and I think within Africa, yes, maybe Kenya, South Africa, to explore some of the approaches to some of the issues that we may have here in Nigeria. But having said that, well done. I will just go with Uncle Max. Thank you very much once again, and my apologies for joining a little late.
All right, thank you so much, Mr. Polarin, all the same. Right, we are still happy all the same that you were still able to still squeeze time to come and be with us. We sincerely do appreciate your presence. You are a very, 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 very valued part of the program and what we do here at Jiipcc. And every time you spend with us is something we consider an honor and a privilege. So to both our mentors that are present in class, Mr. Max and Mr. Polarin, we say a big thank you for everything that you do for us, for both us as an organization and to the mentees that come to partake in this program to learn from the very, very, very best in the industry. I think we are officially done with today's class, right? We've been able to go through introduction as to matters that pertains IP registration. Mr. Max has also touched on the matters that concerns not just the registration, different IP registration. He has also talked on infringement and counter activities for trying to resolve matters of infringement and also the enforcement sides to it, right? And the presentations also did a great job in giving definitions and proper case highlights to instances where infringements and enforcements have taken place. right? So the class has been really, really interesting. I really, really hope that we did all have a great learning experience in today's class, right? As we move on forward in the discussions that we'll be having in the next 2 to 3 weeks, right? I hope that, we're able to really, really make out time to really stay and listen to everything that is being shared, because very thought-provoking informations are being communicated in class, right? So just before we call it a night, finally, like we're supposed to do, for those of us who have lighting in our background, I do not have any lighting. The light situation in my location has been a little bit poor, right, this evening. So please, if you do have some measure of lighting in your background, please, I would like to ask that we turn on our videos for a quick picture, right, to just record that you were in class, and for our social media posting, and we'll call it a night. So let's do that quickly in a minute. Thank you, Mary. I can see your video is already on. All right, thank you, Oluwafemi. Can we have more mentees turn on their videos? Thank you, Eugenia. Thank you, John. Thank you, Tony. All right, thank you, Sparkles. All right, can we have more people turn on their videos? Okay, I can see Daniel, I can see Omotolani. All right,
Yes, that's fine. So just
we'll be doing that quickly. All right, so yeah, we're done with that. Thank you everyone once again for being present. Please do not forget to share what you have learned in today's class, right? Do not forget to share on your different social media platforms. Do not also forget to tag our mentors, right? Let people know that you're actually learning structure, and from the mentors that uh, that are also taking out their time to bring you this level of information for a very, very little cost, right? So yeah, let's please ensure that we are keeping up with posting, and we are just trying to push out the word. And like a friend of mine used to say, spread the gospel of IP, right? So just to say good night, everyone. Please do all enjoy the rest of your evening. Good night to our mentors. Please do all have a wonderful night's rest. Bye bye, everyone.